As you can see, Brazil, India, China, those are major developing countries at the time. So Consultative Party tried to explain itself to the international community. We are a legitimate group to discuss and also decide on the Antarctic issues for the international community as a whole. So based on that expanded Consultative Parties group in 1988, the Consultative Parties, adopted a mineral convention. We call it CRAMRA. However, this was overtaken by the Madrid Protocol in 1991. And we have the Antarctic Treaty Secretariat in 2003. This was a kind of a, again, Consultative Parties trying to be legitimate and increasing its transparency, making their documents available for the international community. What's doing? What are we doing? So the establishment of the Antarctic Treaty Secretariat was one effort by the Consultative Parties to increase its legitimacy. Okay, and from 2002, Malaysia was invited participant in the Antarctic Treaty Consultative meeting. This invited participant is a creation only for Malaysia. We didn't, under the rules of procedure of the meeting, there isn't any category called invited participant. But because Malaysia was very important for the Consultative Parties, because Malaysia was very, against the ATCM, Antarctic Treaty System, so that the Consultative Parties tried to, engage with the Malaysia to actually become part of our group. And actually it succeeded. In 2011, Malaysia became a party to the Antarctic Treaty. And now Malaysia is seeking a consultative status. In 2005, in the United Nations, there is no longer the Antarctic question in its agenda. So it seems like by 2005, the Antarctic Treaty consultative meetings and its system has gained legitimacy to discuss and also to decide on the issues regarding Antarctica, not in the United Nations. The question is it continuing? This legitimacy is actually continuing today? That's the question that I would like to raise today with you. So after that, we have several other Asian countries coming on board the Antarctic Treaty. North Korea in 1987, Pakistan in 2012, Mongolia 2015, Kazakhstan in 2015. They became contracting parties of the Antarctic Treaty. And in 2017, the Antarctic Treaty Consultative meeting made a decision, the criteria to become a consultative party. Because there are so many contracting parties seeking the status of consultative party. And actually, the criteria is more stricter than before, especially with regard to the scientific activities required to become a consultative party. So all this, I think the summary, Japan and other Asian countries are very much at the forefront of the creation and the evolution of Antarctic Treaty system, testing its resilience to changing international relations. The first element of the Antarctic Treaty System resilience is its foundational principles, which Julia has already mentioned. The first principle is the peaceful use. The second is the freedom of scientific investigation. And today, I think we can include third foundational principle of environmental protection. The second element of the resilience is its openness with legitimate restriction. So this legitimate restriction is really the gist of the issue. The Antarctic Treaty is open to all United Nations members and others, but the consultative party status, this means decision-making power, is restricted to those with demonstrable substantial interest, like doing science in Antarctica. The third element of the system, resilience, it's its flexibilities in coping with the political needs of the time. For example, in 1980s, the consultative parties actually lowered the threshold to become a consultative party to recruit many developing countries, as you saw, the China, Brazil, India in 1980s. They actually lowered the criteria in 1980s. This was actually against the United Nations argument. And also in 2000s, we established the Secretariat to increase transparency of the system, to counter-argue the legitimacy deficit argument. However, these flexibilities must be applied equitably and not arbitrarily. So this has become an issue for the consultative parties today. Okay, I wanted to raise two examples to show you today what are the challenges that the Antarctic Treaty System faces today. And I chose two examples from Asian countries. From Japan, there is a discussion in the ATS that bioprospecting in Antarctica should be regulated. And I will give you an example of Japanese bioprospecting, I think I can call it, but of course there is a lot of controversy. But so I'll raise that one issue as an example. And the other issue is, of course, today, the China's involvement in the Antarctica and also in the Antarctic Treaty System has been discussed, not only in the academia, but also in the diplomatic circles. So I wanted to discuss with you one example of a alleged argument, it's only alleged argument, that the Chinese is actually doing a mineral resource exploration, according to this author, whether it's true or not. So to see the resilience, or what are the issues that we need to discuss. But I'm looking at my watch, and I don't think I will be able to cover both of them. And so I would like to just get a sense which one would you like to hear. Of course, the PowerPoint is available for you for later, so you can actually go through them. But what do you think? Would you want to discuss with me on the Chinese case or the Japanese bioprospecting case? Which one? Chinese, okay. I thought so. All right. So let's go that. At least you enjoyed the photos from. So this is the okay. Okay, so this the recent allegation of Chinese mineral resource exploration. Let me see. Is that my? No. I think it should start from here. Yes, I'm sorry. Yes. Now, so this is a very renowned institute, I think, in Australia, Australian Strategic Policy Institute, in 2017 published a report. But this report is written by a professor of international relations, Anne-Marie Brady. And in that report, and I'm quoting exactly, it is written in the report, says, China has never stopped exploring Antarctic mineral resources despite the requirements of the Madrid Protocol. It stepped up its exploration activities from 2012, included a preliminary exploration of mineral resources in Antarctic waters and surveyed coal reserves. So this is exact quotation from this report. So actually, this report is alleging China, against the prohibition provision of the Madrid Protocol, is actually exploring mineral resources in Antarctica. This is a serious allegation. So what is the issue here? So as a lawyer, I think we should look at the issue from a legal perspective. What are the legal provisions which can be a reference in order to look at this issue? The first is, of course, the Madrid Protocol Article 7. Yes, it does say any activity relating to mineral resources shall be prohibited. But there is an important caveat there. other than scientific research. Okay? So is she, I mean, Anne-Marie Brady, is she saying that Chinese surveying activities are not scientific research and the actual mineral resource activities? So it is not really clear from her report. Let's look at the Kramner. Of course, this has not entered into force, but I think there are many elements which we can refer to in order to evaluate the activities, mineral resource related activities, because it defines certain activities which can be considered as mineral resource activities. So according to Kramner, mineral resource activities comprise of prospecting, exploration, and development, but again, does not include scientific research activities within the meaning of Article 3 of Antarctic Treaty. And as you remember, Anne-Marie Brady used the word exploration. So, of course, we have to look at what is exploration under international law. And Kramner provides the definition of exploration. Exploration is aimed at identifying and evaluating specific mineral resources occurrence or deposit, including exploratory drilling, dredging, and other surface or subsurface excavations required to determine the nature and size of mineral resource deposits. So this is the legal definition of exploration. So is Anne-Marie Brady saying Chinese are actually conducting these exploration activities, especially the drilling, dredging, and other surface or subsurface excavations? So those are actually the factual evaluation of the case, not the intentions. So the evidence must come from Article 3, as you can see from Article 1, because under Article 3 of the Antarctic Treaty, if it's a scientific activity, you exchange the results and activities of those scientific activities under the Antarctic Treaty. So the evidence must come from Article 3, information exchange, and not from rumors or, according to Anne-Marie Brady, many of the classified documents which she says she can access, but we do not know the truth of that. So as a lawyers, we should look at the facts, and those facts comes from the Article 3 information exchange. Then it becomes an issue. The Article 3 of the Antarctic Treaty is an important provision, and it is an obligation that the parties to the Antarctic Treaty, they must exchange information with regard to their scientific activities. However, there are certain flexibilities, and there are certain practices where they have actually loosened the obligatory nature of the exchange information obligations by establishing this EIES. This is Electric Information Exchange System, which is very convenient. Diplomats, actually, I know foreign ministry diplomats entering the data through the EIES. It has only certain, how do you say, the limitation to the enter into the information. So you cannot write many things there. It's very convenient for diplomats, very busy. However, because of that, we don't get the information that we really need to know. So it's convenient, and I think it's very good for the administrative purposes. But is it really good for the legitimacy and counter-arguing those allegations by some of the scholars? I think there is a certain way that we can improve this exchange information obligation and implementation of it, so that those kind of allegations would not be, put forward by the academia. So the Chinese case is actually asking the lawyers how we can improve the system. So I think this is the resilience part of the ATS. And if there's any problem with the system, I think we should do something about it. So this is the whole the research the project that the Julia Jabul and Luis Ferrada and I are conducting to see the resilience of the Antarctic Treaty System, and if there are any improvements that we should make, I think we have to put forward those recommendations, policy recommendations, to people like the director of Antarctic in Chile. Okay, I think this. Yes, thank you very much. This is my talk. Thank you very much.